All right. We're on the record, State of Ohio versus Samuel Randazzo, Michael Dowling, Charles Jones, IEU Ohio Administration Company LLC, and Sustainability Funding Alliance of Ohio, Inc., CR 2024-02-0473A through E, respectively. In the courtroom, we have, on behalf of the state, I'm just going to have you guys stand and introduce yourselves, please.
Cheryl O'Brien,
You're from the,
Deputy Attorney General for Law Enforcement for the Ohio Attorney General.
thank you.
Good afternoon, Your Honor. Matthew Meyer on behalf of the State Principal Assistant Attorney General.
Brad Gessner, Summit County Prosecutor's Office.
All right, thank you. On behalf of Mr. Randazzo,
Good afternoon, Your Honor. On behalf of Mr. Randazzo, Richard Blake, McDonald Hopkins law firm, as well as IEU, Ohio Administration, and Sustainability Funding Alliance.
all right, and as I mentioned, you'll file some sort of notice of appearance in this case, please, too. Thank you. All right, on behalf of Mr. Dowling,
Good afternoon, Your Honor. John McCaffrey with Tucker Ellis Law Firm in Cleveland.
all right, and I believe you have another counsel here.
Yes, good afternoon, Your Honor. Steve Grimes on behalf of Michael Dowling, Pro County.
Okay. And then on behalf of Mr. Jones.
Good afternoon, Your Honor. Carol Rendon, Baker Hostetler. On behalf of Mr. Jones, with me is Taylor Thompson, also from Baker Hostetler, and Noah Munyer.
Of the Noam on your law firm. All right, do we have, yes, do we have all counsel on the record now? Okay, very good. All righty, so we are here for arraignment. I think it's best in terms of the initial arraignment portion that we just do each of those individually. So on behalf of Mr. Randazzo, if you'd like to arraign your client.
Good, Your Honor. We reviewed the indictment. We not guilty to all counts that apply to all of my clients.
All right, thank you. And in terms of for the two corporations, would you be also entering a plea for them?
I'm so sorry. Yes.
No, I didn't think to ask you. I realized you were representing all three, so go ahead.
Yes, not guilty as well for both entities, and for the record, one of which is currently dissolved, so it's no longer in existence, but we still enter a not guilty on behalf of it.
And for the record, which one of those is dissolved?
That is IEU Ohio Administration.
All right, thank you.
Thank you.
All righty. In terms of the arraignment portion for Mr. Dowling,
Yes, Your Honor. We had more than 24 hours notice of the indictment. We waive a reading of the indictment, and Mr. Dowling enters pleas of not guilty to each of the 12 counts that pertain to him.
all right, thank you, sir. Finally, on behalf of Mr. Jones.
Your Honor, we have also had an opportunity to review the indictment. We waive a reading of the indictment, and Mr. Jones pleads not guilty to each and every count with which he's been charged.
All right, thank you. So we'll note the not guilties on behalf of all of the defendants. In terms of bond, the court did set what we call it a pre-arraignment bond in order to get us to today of $100,000, 10% with maximum pretrial supervision, house arrest, GPS monitoring, and surrender of the passport. I understand that the state, we were not on the record when I set those, so I would like to give everybody an opportunity to argue regarding the bond. And I'll just note that we did in chambers discuss the specific medical conditions, and that information will be provided to the court under seal. However, we will note that everyone agrees that those will be referred to in general as medical conditions. Otherwise, everything else is going to be argued here in this courtroom. So on behalf of the state, who will be arguing regarding the bond?
Thank you, Your Honor. Matthew Meyer on behalf of the state.
Your Honor, with leave of the court, could we address each defendant separately?
Yes, please.
Beginning with defendant Randazzo, and mindful of the criteria set forth in revised code section 2937.011, we do not object to the bond that's currently in place being extended for Mr. Randazzo. we would request that the GPS monitoring stay in place. Obviously, Mr. Randazzo will need to travel between Franklin County, Hamilton County, where he has a case pending in federal court, and Summit County. But with the GPS requirements that we be confined to those counties throughout the duration of these proceedings. We are aware that a significant portion of Mr. Randazzo's assets have been encumbered. So the concerns that we have about Mr. Randazzo's financial resources are different than those we have for defendants Jones and Dowling. So based on that, we would request the current conditions for Mr. Randazzo remain in place.
In regards to the house arrest component, I did place that just to get to today. Is the state requesting that I keep the house arrest in place, or are you okay with me lifting that at this time?
We're okay with Mr. Randazzo being confined to those counties and seeking leave of court should he need to travel elsewhere. Again, Summit County, Franklin County, Hamilton County.
All right, and if he's on GPS, I would just ask Mr. Randazzo if you would notify, if we remain on GPS, which I haven't decided, but if I did do that, then we would ask that you would notify the GPS whenever you're traveling to one of the other counties. I understand you reside in Summit and in Franklin primarily, back and forth?
That's correct.
Okay. All righty. On behalf of Mr. Randazzo, Attorney Blake.
Thank you, Judge. The purpose of these bonds is to ensure that the party shows up in court. That's it. Mr. Randazzo, as everyone knows, has already been indicted by the federal authorities, not just the county area, but the entire country has, the Department of Justice has deemed it appropriate to have no ankle monitor on Mr. Randazzo. He is on personal recognizance. The man is 74, almost 75. He's not going anywhere. There's absolutely no need whatsoever for an ankle bracelet on this man. We would ask that that travel be constricted to the state of Ohio. He has therapy in Licking County. I am both in Cuyahoga, Geauga County, Lake County, where I would meet with him. It depends on the circumstances. They have to, each time he goes out of one of 3 counties, to ask for permission. If anything, that's just burdensome on the court, burdensome on the individuals, when there's no need for it. And again, he's in a unique situation, having already been reviewed, already been the analysis of his risk flight by the Department of Justice, by the federal authorities, have looked at it and said, in all reality, there's no issue. He's going to show up. There's no politics involved. There's no nothing here. He's going to show up. So I would ask that the ankle monitor be removed, that the 10% of the $100,000 stay in place. And the state is correct. They've encumbered a significant amount of money. To do anything more than that, Judge, is just downright unnecessary punishment for a person who's been charged, but who's innocent until proven guilty. There's no need for him to have to wear that ankle bracelet whatsoever.
Can I ask, what are the charges federally? What level of offense and what are the potential penalties in those cases, in that case?
Those are having to deal.
Sure. The charges are based upon very similar kinds of allegations, Your Honor. Related to very similar claims that are in the indictment before you.
And what are the potential penalties?
The federal government is seeking forfeiture.
The penalties 20 years.
20 years.
20 years.
Yes.
in prison.
Yes.
Thank you.
So those are serious charges, and under those circumstances, we're already there with Mr. Randazzo. There's no need to encumber him.
All right, thank you, sir. All right, thank you. Would you like to respond?
Please, Your Honor. To the extent that Mr. Blake needs the benefit of Mr. Randazzo traveling to his locations in Geauga, Lake, or Cuyahoga, we don't object to that, provided Mr. Blake provides pretrial services with those locations. Our concern is risk of flight. And Mr. Randazzo in state court, the state of Ohio, the charges we are concerned with, faces charges that if convicted and sentenced, could send him to prison for decades, the rest of his natural life. So trust me is not something the court should, view as currency in this court. The GPS monitoring will ensure his presence at trial, and that's why we ask that it continue. I should add, Mr. Blake indicated therapy in Licking County, and likewise, provided there's documentation, we wouldn't object if pretrial services is notified of the circumstances of that travel.
All right. Any final response?
No, Judge, again, this is taking a second bite out of the apple. Federal pretrial services has analyzed this. The United States Attorney's Office has analyzed this. It's just not necessary. It's burdensome on Mr. Randazzo. It's burdensome on this court and the personnel to have another individual to have to say, I'm going somewhere. It's downright mean. It's just not necessary. And I would abide by that. I'd say that we should, not look to complicate the matters here. No one's asking anyone to trust anybody. And this whole issue of decades in prison, he's facing that in federal court. And they've already come to their conclusions. I'm not saying that you have to follow what it's up, and absolutely not. At the same time, it's just uncalled for.
All right, thank you.
Thank you.
And just, we discussed the passport. His passport has already been seized by the federal government.
That is correct, Your Honor.
And you're going to get me something documenting that they already have his passport?
I will do so.
Okay, thank you. In terms of Mr. Randazzo, I am going to keep the GPS monitor on, but I'm just going to limit it to the state of Ohio. And we can revisit that after he's demonstrated to this court that he will comply. We can revisit that issue at a future hearing. And in terms of pretrial supervision, I will impose the minimum pretrial supervision, but I do believe that with the GPS, he would need to keep it charged, and then there may be other requirements from pretrial supervision, so he can talk to them. And certainly, once we get a little bit farther into the case, I will consider a modification beyond that. But for today, we will remove the house arrest.
Okay. Right. Thank you.
Thank you. Okay. In terms of Mr. Dowling, go ahead, Attorney Meyer.
Your Honor, with respect to defendant
Is your
Dowling.
mic turned on?
Beg pardon, Your Honor.
Thank you.
With respect to defendant Dowling, the state did address the court yesterday and requested a financial bond. In review of the case since yesterday's discussion, mindful that the purpose of revised code section 2937.011 is to secure the defendant's presence at trial, we would ask for a property bond that Mr. Dowling post the property he owns in Stark County, Ohio, and in Mount Pleasant, South Carolina, both his home and the vacation home. We think that would serve as an adequate deterrence to flight. Mr. Dowling, while he was not compensated in quite the scale by his former employee, his employer, Mr. Jones, that Mr. Jones was compensated, he still enjoyed significant financial compensation upon his exit from the company. He has access to resources that we are concerned could be used to further flight. The strength of the evidence, which is another statutory factor, and with due respect to my friend for the defense, is something the court should consider. My friend for the defense indicated that this is an irresponsible accusation. We do not believe this is a $4.3 million coincidence. In fact, we have writings that indicate the defendant's mindset and intentions behind the actions described in the indictment. So the evidence is significant before you, and that is something that the court can and should consider with respect to flight risk. The defendant has substantial resources, and if his property is on the line, I think that would be an adequate deterrent to flight.
All right, would the state consider a freeze for any sale of those properties while the case is pending and an alternative?
Well, that would be one possibility. It doesn't remove the incentive to flee. He would lose those properties eventually.
If he fled, then he would lose those properties.
And so we would request that the GPS monitoring stay in place. And likewise, Your Honor, as to Mr. Dowling, similar to Defendant Randazzo, we would request that he be confined to the court's jurisdiction to ensure his presence at trial, verified through GPS monitoring.
All right, Attorney McCaffrey?
Thank you, Your Honor. Your Honor, as the court is fully aware, the court is mindful of imposing the least restrictive means upon which to ensure the defendant's appearance at any subsequent proceedings. Mr. Dowling fully intends to appear, Your Honor. He, as we discussed yesterday, the facts and circumstances that are alleged in this indictment are similar to at least 6 to 7 other similar civil cases. In fact, one of them is a civil case brought by the Attorney General's office. It is a RICO conspiracy case that was filed in 2020. So these allegations are certainly no secret to Mr. Dowling. He has done nothing to change his financial conditions. He's owned both his home up here in Massillon, where he's lived with his wife for 34 years, for many years, lived in the Massillon area for many years. And he's owned those homes before these allegations came to be known. He's done nothing to do anything with those properties. Mr. Meyer talks about financial resources, but other than the 2 properties, he's not identified any, because there are not significant financial resources. Mr. Dowling has a modest pension that he draws from FirstEnergy, but other benefits have been held by FirstEnergy, and he does not intend to do anything with those properties. Your Honor, he's an Ohio resident. He surrendered his passport. He, as mentioned, his wife of 34 years. He also has a daughter and a son-in-law and a 3-year-old grandson that he is very much involved in the care of his grandson on a regular basis. He and his wife care for their grandson every week because both the daughter and son-in-law work. They live approximately 20 minutes, 30 minutes from the house. So if the court would be inclined to maintain the GPS monitor, we would ask for some ease of that so that he could go to watch his grandson or pick his son up and bring him to the house. Also, he needs to come up to Cleveland and see counsel. There may be occasions when he needs to get around to go to church, etc. Your Honor, he is not at all polite risk, as I've indicated, and we ask that the court has already imposed a fairly significant and standard surety bond that's in place. He's posted that. We ask that that be maintained and that there be some easing with the electronic monitoring as requested. Thank you.
In the RICO case, has there been any freeze of assets from the AG's office?
There has not. No, there has been with respect to Mr. Randazzo, but he's the only defendant for whom there was any attempt made to freeze assets.
All right. Sorry, so the same prosecutor. AG Meyer.
My only follow-up would be, to the extent there's representations about access to financial resources, if Mr. Dowling is taking the position that he does not have the millions of dollars that FirstEnergy paid him, that he be sworn in and say that on the record for himself.
Response.
Yeah, I mean, I see, the state has offered nothing beyond just talking about the property. He does not, he is not worked for FirstEnergy since October of 2020, so I'm not sure when the state claims that there are all these financial resources, exactly what Mr. Meyer is referring to. I know there's some benefits that have been frozen by FirstEnergy, and those are not available to him.
Okay. I hear what the state is saying on this. However, I feel that the bond that's been set is going to be sufficient. I will remove the house arrest component, but again, I'm going to keep the GPS monitoring on at this time, and I'm going to restrict it to the state of Ohio, and that way you can travel to see council in Cleveland, family in Summit, and live in Stark, rather than setting off monitors because he goes, you know, into Portage County briefly on the highway or something. I just prefer to just leave it state of Ohio and keep it simple.
Thank you.
All right, thank you. All right, for Mr. Jones, AG Meyer.
So with respect to defendant Jones, Your Honor, we do have significant concerns about flight. Mr. Jones is identified that he's a resident of Naples, Florida. That's a relatively short boat ride to a country with no extradition jurisdiction to the United States. And he also has access to substantial financial resources. And this one, I can state for the record, $55,934,142.77 was paid to him by FirstEnergy. So that amount is a staggering amount, and my friend for the defense yesterday suggested that this was a routine case. This is anything but a routine case. It is a question of access to resources that would enable flight and a significant incentive to flee. Mr. Jones, again, faces the prospect of spending the rest of his life in an Ohio State penitentiary if convicted of these charges. He owns properties in Naples, Florida, as well as Summit County, Ohio. It's our understanding that the properties in Naples, Florida are valued at $9.4 million and $1.1 million respectively, and a property in Summit County valued at $1.3 million. Mr. Jones has, through counsel, taken the position that his need for medical treatment should allow him to travel freely to Florida and remain in Florida while this case is pending. The state takes strong exception with that. We are aware of the nature of Mr. Jones' medical condition, and we are of the position that the provider of medical treatment is also an entity that provides medical treatment in Northeast Ohio, world-class medical treatment. And if there is a will, there is a way. If the court's order is that Mr. Jones receive his medical treatment within the court's jurisdiction to ensure he does not flee, then I suspect that the necessary professionals will make the necessary arrangements. At a minimum, though, I think Mr. Jones should post the value of those properties, post the properties as a disincentive for flight. He has the resources, the means, and the ability, should he choose, to be drinking a Cuba Libre, so to speak, 100 miles away from where he lives in Naples, Florida.
Thank you. Attorney Rendon, I believe you're going to speak on behalf of your client.
Thank you, Your Honor. Carol Rendon, Mr. Jones. First and foremost, Mr. Jones is not a flight risk. He has known about this investigation since last summer, the investigation by the state of Ohio. He's known about a federal criminal investigation since July of 2020. There are multiple pieces of civil litigation pending. Mr. Jones has appeared and participated in every one of those. He has known since the summer of 2020 the potential penalties if there was a criminal charge that he might face. He knows what the penalties are here. If he was going to flee, he would not have waited 3.5 years, Your Honor. And the idea, the insinuation that he would flee to another country is just really not appropriate under these circumstances. He's done everything that you would ask somebody to do under these circumstances. He has stayed put, he has showed up, he has participated, and he has affirmatively stated that he is innocent of these charges. And that presumption of innocence is critically important in this court's determination as to what an appropriate condition of bond is for Mr. Jones. He is a resident of the state of Florida. He's been a resident of the state of Florida since 2020, before any of these investigations began. He didn't move to Florida because of these investigations, and he should be permitted to return to his home. Your Honors, you know, because of his medical situation, there is a specific need for him to be in the state of Florida where he lives, and a particular need for him to be there next week. The GPS monitor, Your Honor, which I understand the purpose of it, is very difficult as a result of those medical conditions. And I don't think it will be something that Mr. Jones can actually do on a long-term basis, Your Honor. And I think it will impede the other things that he has to do in terms of his medical conditions. And so I don't think that a GPS monitor is either necessary or appropriate under his unique circumstances, Your Honor. If Your Honor wanted, Mr. Jones would be more than happy to return back to Naples for the appointment that he needs to be at next Tuesday, come back to the court and have a pretrial services risk of flight assessment done, which I know you often do when you have more time in advance of an arraignment, and to give that additional information to Your Honor to consider. But I think that the fact that he has surrendered his passport, the fact that he has stayed put and has appeared as requested to this court, he came back to the state of Ohio as soon as he was advised by counsel that this indictment had been returned, and awaited Your Honor's instructions yesterday as directed. He's not going anywhere, and you can be assured of that. So my recommendation, Your Honor, would be that the surety remain in place, the court has possession of his passport, he be permitted to return home, and then if you would like him to come back on a designated day next week, he will travel back, you know, we can have an appearance with pretrial services and do an additional risk assessment for Your Honor to consider in terms of long-term conditions pending the trial of this case.
AG Meyer.
Thank you, Your Honor. Matthew Meyer on behalf of the state. With respect to the issue of the medical complications and GPS monitoring, it's my understanding that the device can be installed, for instance, on an arm, and I'd ask the court to keep the GPS monitoring in place. Once there is a flight, despite the best intentions, representations, and promises of lawyers, then the court is beyond power to retrieve the defendant who flees to another country where there is no jurisdiction. This is a defendant who has access to the resources to make it possible, and this is a defendant who has a strong incentive, given the nature of his medical condition, which we've discussed in chambers. In particular, the prospect of decades in an Ohio State penitentiary make the risk go up. And so, with that in mind, we would request that the GPS monitoring stay in place, and at a minimum, the court impose a disincentive to flight that would cause him to think twice about even suggesting that he flee jurisdiction. And that would be to place the properties he owns, the vacation homes, the property in Florida where he now resides, and the property in Bath, Ohio, as collateral to ensure his appearance. That would be an incentive to stay. I don't think it's an unreasonable request under the statute, and it would not unfairly impinge on his liberty. With regard to civil cases, those civil cases, like I said, do not carry the prospect of decades in an Ohio State prison. Finally, I would like to note for the record that the state did provide Marcy's Law notification to the named victims in this case. FirstEnergy Corporation has been provided notice and has a representative here today, and the industrial energy users of Ohio have likewise been provided with notice. It's my understanding that neither of them intend to make any statement today.
Thank you. I appreciate you getting that on the record. Final?
Your Honor, if I might respond briefly. If the court needs some additional assurance that Mr. Jones will appear as required, and he will, Your Honor, I know that he would be willing to agree to freeze any sale on his houses. I think he would even be willing to put up one of his houses as surety if that was his support, because the GPS really is not, it's going to be so difficult for him physically, whether it's on his ankle or on his arm, it doesn't matter. It is going to have a negative impact on his health and his medical condition. And so if the state thinks that that's going to keep him here, they don't need it to keep him here, we would be willing to do that, Your Honor, so that he doesn't have to wear the GPS monitor.
Okay. The purpose of bond is not only to ensure that someone will get to court, but also, have to take into account their risk of flight. And certainly, someone living in Florida is a very different risk than someone living in Ohio. At this point in time, I am going to limit Mr. Jones to the state of Ohio, and I'm going to keep the GPS on. I will allow them to move it to his arm, and I will ask you to contact the Cleveland Clinic and see if they can manage to get that treatment done up here with a week's notice. And if not, if Cleveland Clinic gives me a letter that says he needs to go down there to do that, then I'll allow him to travel down to get that and come back up to Summit County. But for now, while this is pending, I don't want him that far away from us. That doesn't feel appropriate right now. And then I'll also order a freeze on the sale of his home here in Summit County. We can discuss further bond conditions as the case progresses, as I've indicated previously. ARM is not an option for GPS. I was wondering that. There are some devices that are like a watch, but I don't think we have those here in Summit County. So, Attorney Munyer, you seem ready to say something, please.
Judge, I believe there is a handheld unit that he can carry with him. It's not attached to his body. Am I correct in that? I think they have that through pre-trial.
They might. If they do, I would be satisfied with that for now, just so that I don't want to cause any additional medical issues for him. However, I have a duty to the state of Ohio to make sure that I ensure his presence in court throughout this proceeding. So is there anything further then? I would note that I did receive documentation that both Mr. Jones and Mr. Dowling have surrendered their passports as ordered, and that'll be stored by the court, Summit County. Attorney Munyer?
Yes, Your Honor, I just wanted to clarify that the restriction is to the state of Ohio as it is with Mr. Dowling.
Would he have any reason to be that far south in Ohio?
He has a child who lives in Columbus, and I'm in Cleveland.
Right.
So, yes.
I'm comfortable with that.
Thank you.
All right. For now. And we can look at this as we go through the case, and I continue to see compliance. We can, have further discussions about the bond. But for now, I feel comfortable with what we've resolved today. So we'll continue on all three. We remove the house arrest. The only added condition is to freeze Mr. Jones' home asset here in Summit County as an assurance that he will stay. And just provide us with that documentation from Cleveland Clinic if that is going to be an issue.
Your Honor, I've just provided my friend for the defense a copy of the Zillow record of Mr. Jones' Summit County home. If there's no objection, I'd like to provide it to the court as an exhibit of the property that we are asking to be enjoined.
Is there any objection?
I have no objection. I have no idea, the
Right.
authentication of it, but I have no objection to it.
All right. Would you want to make that an exhibit for our court reporter then?
Yes, Your Honor. State's exhibit, hearing exhibit 1, please.
All right. All right, we need to talk about what's next. I guess that's the other thing we need to do. I would guess that there's significant discovery that needs to be reviewed by the defense. Have you updated any discovery yet? I mean, I realize this just happened, so I'm guessing little or none?
None.
None, okay.
Thank you, Judge.
All right. So what level of discovery do you anticipate being provided in terms of volume of documents and that type of thing?
I think at the outset, we're going to provide discovery in several stages. The initial batch will most likely be the most significant batch. There's approximately 100,000 documents that we'll be turning over. I would have proposed to my friends for the defense that we make arrangements about the means to turn that over, well, most likely on an external digital media. But we're going to be compiling that in the next, I would say, 3 weeks, and have that ready for disclosure as an initial production. Thereafter, the productions will be much less significant, but will be more of the traditional casework material that will be provided in that second batch.
All right, so anticipate it's going to be the beginning of March before they even get the documents?
With leave of the court, yes, Your Honor. And I think the state would note that it will request reciprocal discovery in kind of the defendants.
Absolutely, as required by the rules. So are we thinking we might be best suited to have a hearing sometime in April? Just a first pre-trial? Not a hearing, but just a pre-trial? That would give you guys about a month after you receive those documents, just for us to come back and start talking about what's next.
That's fine, Your Honor, for an initial pre-trial.
Okay. Perhaps we could put that on a Friday morning, not on my call day. Is everyone okay with Zoom for a hearing as far as that pretrial? The court usually does our arraignments in person, any hearings in person, and a lot of our pretrials are on Zoom. However, if the parties don't wish for them to be in Zoom, obviously I don't have a problem putting people in the courtroom, so. Does anyone object to Zoom? Let's put it that way.
Not on behalf of the state, Your Honor.
This would be counsel only, Your Honor.
No, the pretrials, we actually have the parties there just so that I lay eyes on them regularly. Yeah. But that would be on Zoom.
Excuse me, Your Honor. No objection on behalf of Mr. Jones.
All right.
No objection, Your
All
Honor.
right.
Thank you.
So let's schedule a Zoom hearing in about 2 months then. So that would be around April 12th. In the morning sometime, would that be doable? And then we're gonna start hitting everybody's calendars, right?
I would only ask, Your Honor, I am in a trial in Cuyahoga County that will probably go through the middle of April. I would
Okay.
tell the judge, they'll give us a break if need be, but I would ask for the 19th or the 26th for myself.
All right. How's the 19th and 26th for the other two counsel, for the defense?
Judge, I'm in Toledo in trial. The week of the 22nd, I could do the 19th.
The 19th would be better?
Yes.
How about for the state?
We're at the court's pleasure. Those dates will work for us.
All right, Attorney Rendon?
So I can attend via Zoom, but I will be out of town for a family-related event.
Okay.
So I can attend via Zoom, but I just didn't want Your Honor to wonder where I was. I won't be sitting with Mr. Jones because I will be at a college event.
I would guess with the counsel involved, that someone will be sitting with them.
That's correct, Your Honor.
All right. Let's do that. Would you be available at 9:30 that morning, everyone? I do have a couple things already set at 8:30. All right, so we'll set it for April 19th at 9:30 for a Zoom hearing. And if there's any issues that come up before then, any motions that are filed, I can set hearings accordingly, obviously, with the coordination of calendars being what they are. Anything further for the record at this time?
Not on behalf of the state of Ohio, Your Honor.
Nothing on behalf of Mr. Rendazzo.
Nothing further, Your Honor. Thank you.
Your Honor, nothing's, I'm not going to go back over everything, but if you would order a pretrial risk assessment, I would appreciate that.
Sure, we can ask them to do a pre-trial risk assessment for all three defendants.
Thank you, Judge.
And we have checked with pretrial, they do not have anything other than an ankle monitor. So for now, we use the ankle monitor. You can ask them to put it looser so that if you have any swelling issues. And then also, you know, we can address it if something comes up in that regard. All right. Okay, if there's nothing further, thank you. Thank you, everybody.
Thank you, Your Honor.
Quorum.
Thank you, Your Honor.